Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near to their attendance and they shall be heard.
Good morning. Please be seated. First case for oral argument this morning is 385 People versus Moore.
Good morning, Your Honors. May it please the Court. Mr. Moore, having been acquitted by a jury of 2 counts of menacing in the second degree, should not, at his second trial, have been subjected to the burden of defending against those accusations already decided in his favor. The people had a full and fair opportunity to prove their case, and having failed, it was inequitable to permit the prosecution to present the evidence underlying the menacing counts as if the first trial had never taken place.
Did that evidence have anything to do with crime for which he was standing trial at this trial?
No, the 2 menacing counts are temporally distinct from the 3 counts which hung in the first trial. And that's why in this case it was so easy to excise that testimony from the trial without impacting.
Wasn't there a 2-hour difference also between the alleged menacing and purported shooting?
That's correct. The exact timing of the menacing event is not in the record. The indictment charges it as if it occurred around midnight, naming both days. From Marcus Buckman's testimony, it's roughly 2 hours prior to the shooting and the murder.
So that it was easy to not bring those in the second.
That's correct. And I think this case is controlled by the Court of Appeals decision in O'Toole as well as this court's decision in Williams. This court gets it right in Williams, and it says that we only decline to apply collateral estoppel.
Don't we always get it right?
Thank you.
Yes, Your Honor. When a witness is caused to give untruthful or misleading testimony, and that's just not the case here because these are 2 separate events. And I would note that to the extent that the people argue that it was relevant, that this chain of events was relevant, 2 things on that. I agree, but you lost it at the first trial. You don't get it. You don't get a second chance to establish those.
And but they just brought up there was an argument between the individuals.
That's correct. And the sort of the key part of what makes their story, where Mr. Moore, according to Mr. Buckman, Mr. Moore says, "Hey, why are you bringing new people around in the neighborhood? I feel threatened by you bringing new people into the neighborhood." That sort of establishing a motive, say, if that's what they want to do, they can still establish this verbal altercation that takes place at the park.
I think we understand that.
Okay. I'll move on from collateral estoppel if the court has no further questions, and I'd like to address suppression because this is an independent ground for reversal, but also if the case is remitted for a new trial, the suppression issue matters as well. And we submit that Mr. Moore's arrest was illegal for 2 reasons. The first reason we submit that it was illegal was that RPD in this case...
Question, was this issue of suppression dealt with before the last trial?
Yes, the suppression hearing is before the first trial, and the suppression rulings remain constant for both trials.
But you're asking us to look at them anew, or not?
Yes, I am. I'm asking this court to review the suppression decision. And before the trial court, the defendant argued that RPD's misleading nature and what essentially that the way they misled the Amtrak Police Department into believing that there was a warrant, that is a basis for suppression. And I urge this court to consider that.
Didn't the Amtrak officer believe that the reason for the arrest was probable cause and not the arrest warrant?
I disagree, Justice Montour. He testifies we were operating under the assumption there was a warrant. And he testifies that Detective Correa told him there was a warrant.
But I thought that he indicated also that the arrest was made on probable cause.
And what we do concede is that probable cause was communicated from RPD to Amtrak.
If you look at the fellow officer rule, the officers and RPD officers had probable cause.
So we're not submitting that the arrest is illegal under the fellow officer rule. We do agree that there was a phone call between Detective Balk and Detective Correa in this case, in which the probable cause was transmitted. Why we submit suppression is necessary is that one law enforcement agency should not be misleading another. In this case, they communicated their probable cause, but they also communicated we have a warrant. And they did that verbally, according to Detective Balk. He says that Correa told him there was a warrant. And they also do it by making this NCIC entry, which indicates a warrant has been signed by an empowered authority. And they testify that they know that language is going to appear in the NCIC warrant, and they know that other agencies are going to rely on that NCIC alert, and they do it anyhow. And I think they do it because, as Detective Zenilovich testifies, other agencies typically want a warrant or, quote, something tangible. And I think they're trying to give them something tangible that looks like a warrant, but there is no warrant in this case. And I think that is police misconduct, one agency misleading another, and that's the goal of the exclusionary rule, is to deter this type of police misconduct.
Okay, we'll look at that very carefully.
The second reason that we submit that the arrest was illegal has to do with the Uniform Criminal Extradition Act. And this court should hold that when New York State law enforcement wants to effect an out-of-state arrest, they must comply with the Uniform Criminal Extradition Act. The people seem to submit that compliance with state procedural statutes is not something that leads to suppression when those procedural statutes are broken. But this court in Burke, just late last year, ordered suppression in a case that was a fairly technical procedural statute dealing with arrest warrants again. So in this case, not only is it a violation of the Extradition Act, but it's an intentional violation of the Extradition Act. The Extradition Act creates this condition precedent to an arrest for an out-of-state crime, and that condition is that the suspect must be charged in another state. The statute is very clear. It's a uniform act, so it's identical in Illinois as in New York. And yet, RPD is taking actions to effect an out-of-state arrest without charging Mr. Moore for any crime in New York. So I'm asking this court to hold that this is not a superfluous statute, but that law enforcement must actually comply with the statutes our legislature has enacted. Lastly, I would say that reasonableness being the touchstone of the Fourth Amendment, as well as our state analog, intentionally choosing not to comply with state statutes is a patently unreasonable action for law enforcement to take. So we submit that the fruits of the arrest must be suppressed. And there's an additional reason for Mr. Moore's statements to be suppressed. They are one of the fruits. And that is that he is told that there is a warrant for his arrest. He's been told that by Amtrak during the arrest. They were telling him, you got a warrant out of Rochester, that's why we're arresting you. But then when he repeats that in his interrogation, the interviewing officer says, yeah, you got a warrant. She confirms his belief that there's a warrant. And this is exactly the kind of action, the type of misrepresentation during an interrogation that's known to be a catalyst of false confessions. And I think that this is a tactic to overbear the will of a suspect, and police, I think it renders his statements involuntary, and this court should so find.
Well, even if the statements were suppressed, I mean, the evidence is overwhelming. There was an eyewitness testimony of an individual who knew this defendant for more than 10 years, and that he saw him shoot him in the head.
So I think that the evidence of the statements, I would submit that it is not harmless. This case really centers around Marcus Buckman's testimony. It's a credibility trial about Marcus Buckman, and as we know, in the first trial, they acquitted on the menacing counts, which the evidence of those only came from Marcus Buckman. So Marcus Buckman is not a great witness for the people. He is very vulnerable to attacks on credibility, and I think that makes this a very close trial in many ways. Though some of there's certainly some forensic evidence about the location data, but that's not dispositive in this question because you've got, in fact, 4 men on the scene where this murder is, and all but one of them leaves before the police arrive. So there's a lot of room in here for credibility questioning over who committed this murder.
I think we have that. Thank you.
Thank you, Your Honors.
Good morning. Any analysis of collateral estoppel requires this court to look at what did the first jury rule. And yes, the defendant was acquitted of menacing. However, but what is also required by O'Toole, which is referenced by defense counsel, is that this court apply a practical and rational reading of the record. To convict defendant of menacing, the jury would have to find that the victims were in fear of some sort by way of the gun. There was no evidence, obviously, because one victim was deceased, and the other victim clearly was not afraid because, he pretty much taunted the defendant by saying, you cocking your gun at me? And he knew that the reason why he was doing it was towards the now deceased victim. So I submit to you a rational and practical interpretation of this record shows nothing other than the fact that The jury found that there was insufficient evidence of an intent to menace because we couldn't put any witness on the stand to say that they were so menaced. And in fact, a TOD motion maybe should have been granted for the menacing as it pertained to the deceased victim because it would be impossible to prove that case. And supporting that is the fact that this jury was 11-1 to convict on the remaining charges. This wasn't a complete discount of Marcus Buckman's testimony. Clearly, they believed that there was evidence of a possession of a gun. Everything lines up as what O'Toole tells us to do, and that is to look at what the jury saw is that they just found insufficient evidence of an actual threat, that these two individuals were actually threatened. And I think that the controlling case here is Ortiz, which I cite in my brief, and that involves the acquittal on the Berg 1, conviction of a Berg 2. On the retrial, the court allowed testimony with regard to the razor, which is what would have elevated it to a Berg 1. And the Court of Appeals said that was fine. And I think that Ortiz is controlling, and under these circumstances, collateral estoppel does not bar testimony with regard to what happened at the park. And I would also note that the menacing in the park had everything to do with the murder. And I think that what's significant is that the victim in this case, immediately prior to the murder, was completely silent.
Why would you need the menacing case when you have an eyewitness that says shoots the individual in the head?
Well, and clearly, absolutely. However, what the victim says is, the last thing that the witness says is,
the victim's dead.
the last thing that the witness says is to the defendant when they're at the park is, you cocking your gun at me, you're cocking your gun at me. When they're just before the murder, there's a discussion between the witness and the defendant about what had happened earlier. Eventually, the victim of the homicide says, what EQ, which is the witness, says is true. By the way, I keep my shit cocked too. And at that point in time, he's shot in the head. So I don't see how you can't see a connection between the two crimes. I will move on to the probable cause to arrest. And I guess I just want to clarify preservation, because it's not an easy to wrap our brains around that in this case. But I think that if you look at the motion papers and the post-argument submission predominantly, you can tell this probable cause argument below was based upon the fact that a claim that the fellow officer rule should not apply. And that the fellow officer rule should not apply because they believe that the testimony provided was not sufficient because it was based on inaccurate information. And because of that, the probable cause rule should not apply.
Shouldn't the rule apply, isn't it, based upon the fact that they believe that the fellow officer, the one making the representation to the arresting officer here, had his information was correct, and then him saying I got a warrant obviously wasn't accurate. So why should we rely upon the fellow officer rule when it appears as though the reporting officer is giving inaccurate information?
So the
Don't you rely upon that? Rely upon the...
Yes, because I don't recall exactly where in the transcript the investigator says we had a warrant. The NCIC transmission that was generated made reference to a warrant, but that was explained, and I think that it can be discounted.
Was it explained when they were calling him, we got probable cause here, or to arrest this individual? Because
it was, I don't believe it was arrest this individual, it was detain this individual, and that probable cause is substantiated, and that probable cause is not disputed on appeal. They don't claim that the officer did not have probable cause because they fault the officers for not getting an arrest warrant because they had probable cause. That's why it's so difficult to intertwine here. But, I would like to, I don't remember in the record where a police officer testified, I told the investigator in Chicago that we had a warrant. The NCIC
was there a temporary warrant referenced?
No, it wasn't a temporary. It was self-populated. When they put on a stop and detain, it populated into the NCIC as a warrant. But I think it's significant is that there's a miscellaneous box on the actual NCIC transmission, and in bold lettering, it says, I believe, stop and detain for questioning. So to the extent, yes, to the extent that the NCIC did mention a warrant, it was immediately clarified in the box underneath. And the investigator in Chicago testified, look, I have never had a situation where a warrant's been issued that there's not a number, a warrant number corresponding with it. And counsel has selected choice sections of the transcript where he said, yeah, I thought it was a warrant, but the investigator in Chicago also said, look, I use warrant and want interchangeably. And he said that he did not believe, based on the NCIC, that there was a warrant. And it was predominantly because of the fact there was no number on it. So, I do believe that the argument is framed on appeal is not preserved. Both the argument with regard to the, I always get the acronym wrong, the Extradition Act, whatever the acronym is, because I don't believe that was cited. They cited a different statute based on a failure to immediately arraign. But in any event, Burke doesn't control. Burke involved, I believe it was another county in New York State. It wasn't this court making a determination on an out-of-state matter. That's my recollection of Burke, and I defer to the court on that. And this court can't step in. Illinois has their own statute with regard to when they can make an out-of-state arrest. And they can make an out-of-state arrest if they're given probable cause to believe that the individual that they're stopping and detaining there's probable cause for his arrest. And there is no dispute on appeal that they had that here. I do want to briefly talk about counsel's reference to, I believe that it's patently unreasonable for an arrest to stand in violation of a state statute. And I believe that she's making reference to the fact that they chose not to get an arrest warrant. And I do believe that the Court of Appeals has spoken on that. And it's not identical to this case, but the Robles case, and I think is even somewhat more egregious. And I do have the case site, but I think it's pretty well known to everyone. It's 72 NY 2nd 689. And in Robles, the DA actually dismisses a charge so that the police can interview the defendant on other matters. And they do that, and there's talk about circumvention of a right to counsel. And what they say is law enforcement needs an objective standard. They need to know when they can and cannot interview a defendant. And the law as it stood when these officers dealt with this case was that there's no constitutional right to arrest, and they played by those rules. And under these circumstances, we submit there was no flagrant violation of state law, and that the Court of Appeals really has addressed this. And do you have any questions? Want me to rely on my brief?
Thank you.
Thank you.
387, People versus Commissioner. Did I come anywhere close to getting that right?
I think you're close to it.
Okay.
Good morning, Your Honors. Jane Yoon for Mr. Comisher, which is, I believe, how it's pronounced. So I think you were pretty close, Judge. The evidence here from the trial was legally insufficient to establish a serious physical injury. Now, there's no dispute that the complainant here was injured, but the evidence here just does. Oh, I'm sorry. I thought you had a question, Your Honor.
I'll jump in here. All right, so my reading of the case reveals that he had an impairment to his eye and his face and from getting hit with the butt of a gun, and that he later had to have surgery to rebuild his nose, as he explains in the transcript. Isn't that serious injury?
I think it's an injury, but based on the legal definition and the case law that has established what a serious physical injury is, I don't think there's enough on this trial evidence to establish the serious physical injury. Yes, there was, surgery,
Did he have
reconstruction.
his vision that was affected for like 8 months as well?
It was, but what we
What more do
don't,
we need to get serious injury?
well, we don't know if it's a permanent impairment, because there's no medical testimony other than the medical records. There's nothing about the post-operation
Didn't he
diagnosis.
have a plate put in his cheek?
He did, Your Honor. Again, we don't know what the prognosis was because there was no medical testimony. And I understand we don't always need medical testimony. But here we have, there's facial reconstruction surgery, sure. People in modern day medicine have metal and screws for many different kinds of.
On this argument, we'll look closer. Why don't you go on to your next argument?
I will, Your Honor. Thank you. I think I would like to discuss, I'd like to move on to point 3, actually.
having a theory of defense is not the same thing as having a strategy. You can have a theory, but if you don't have a plan as to how to make that theory come across to the jury, then that's the same thing as not having a strategy at all. And here, I know the court is familiar with all of the instances that we believe contributed to the lack of a plan here, and I would like to highlight some of the more egregious points of counsel's inactions in this case. There was extremely prejudicial information that came in during the trial that has absolutely no relevance at all to the assault. Either there was an assault that happened as the way the complainant said, or there wasn't. So the information that came in about the search warrant and the execution of the search warrant and the snipers on the roof and the SWAT teams just for Mr. Comish's arrest are not relevant to whether there was an assault. And counsel...
Well, there was, counsel, I'm sorry, but there was a point there that the defense counsel was trying to make that the victim had exaggerated not only the assault, but everything that was going on in the wingnut shop.
That's correct.
And that was part of the theory here.
Well, and I think that's...
That all of this cumulatively made the victim look less believable.
Well, I think that's the problem. When you're weighing prejudicial information that comes in against your client, against the best way to attack the complainant's credibility, there's certainly decisions to make, and this was a bad decision, and it's not just an unsuccessful decision. It made no sense based on the other information available to attack the complainant's credibility. And I think the other thing we can look at is defense counsel's plan to get out some sort of a justification defense was to call character witnesses that the procedural law prevented her from calling, which she didn't seem to really appreciate until she got to the trial. And so, again, you can have the theory of defense. I'm going to explain to the jury why he's not credible, rather than precluding all this prejudicial information that simply just makes Mr. Comisher look like a white supremacist thug.
She had a real problem because of those text messages that put the victim in the shop at the time the alleged assault took place. So she had to somehow undermine the credibility of this victim, who, by the way, had a titanium plate in his face that fixed the multiple face fractures. So it was an assault.
But the text messages were prime, actually, fodder for cross-examining the complainant. I mean, he texted me and says, I have $200 for you. We have the text message. There's nothing in the text message that says that that's what brought him to the shop. So, there's one way first to attack his story about what happened that day, right? And again, the fact that counsel seemed to be so reliant on these character witnesses that, anyone who understands a procedural law, I mean, the court had to instruct her and the prosecutor had to instruct her.
We understand that.
So, because of the credibility of the witness, because that was the key defense, as argued in my point too, I think that was extremely prejudicial. And then, it sort of snowballs into the comments that were made on summation. So to the extent that there's an argument that the prosecutor was merely responding as fair comment to the arguments made by defense counsel or that were brought up during trial,
I think we got
that's
that.
really defense counsel's
Could
fault.
you address, what about the court's failure to rule on the
Well, I think ordinarily the court could send this back, certainly, to the trial court to rule because there was no decision. But I don't think that the court's failure to rule on the TOD motion prevents this court from reviewing the sufficiency claim under either its weight of evidence review power per Danielson, since you'd have to review all the elements to see if the necessary elements have been met, or even in the interest of justice. So we would ask the court to review it on those grounds and reach the merits. Thank you, Your Honor.
Good morning, Amy Wallensack on behalf of the people. Unless the court has any questions, I will rely on my brief for point one. It's our position that the permanent insertion of the titanium plate into the victim's face qualified as a serious injury, along with the vision loss that was testified to. With respect to point three, defense counsel here had a strategy. It was discredit the testimony of the victim who clearly was assaulted at some point. It's our position that there was a strategic reason to bring in the evidence of the search warrant and the high-risk nature, and she attempted to point the victim, or to portray the victim as somebody who made these outlandish and unbelievable accusations, so you can't believe what he's saying about the assault. And I believe that if she hadn't brought that up at trial, we could probably make the same argument that she was ineffective for not choosing to use this massive inconsistency to discredit the victim. And also, I would say any prejudice to the defendant with the testimony about the high-risk nature and everything was mitigated because the police did not find any of the meth lab, stolen cars, etc., that the victim testified to. That was the whole point, was that it did not ultimately bear any evidence of those crimes. And also, a justification defense would have been inconsistent with saying defendant simply didn't do this and the victim is not credible, and it's entirely reasonable to choose one strategy over another based on the facts of the case. Also, just briefly, my understanding of this court's case law is that because the court did not rule on the TOD motion, it needs to be remitted for a ruling on that before this court can reach the legal sufficiency issue, and I will otherwise rely on my brief.
Thank you. 388, People versus Hubbard.
Good morning, Fabian Santacroce for Isaac Hubbard. Unless the court has any questions, I would rely on my brief. Thank you.
Good morning, Marty McCarthy for the People. I can do the same unless there's any questions for me.
I have one question. What about the order of protection? Shouldn't
So
that should be modified, wouldn't you say?
Well, I will point out one fact that is not in the record. When you consider whether you can exercise your interest of justice jurisdiction because the issue was unpreserved, this defendant had a subsequent arrest, trial, and conviction involving the same victim, and a new order of protection was entered in August of 2023, and that new order of protection doesn't have that language.
Okay.
So to the extent you still want to exercise your interest of justice jurisdiction to in essence accord the defendant what he thought he was getting, that's fine, but with respect to the defendant, as long as this new order of protection is in effect, it won't have any practical effect for him.
Okay.
So no other questions?
Thank you.
Thank you.
389, Dunahee versus Crawford. Danahee? How do you say the name?
It's Danahee.
Danahee. Okay, thank you. Good morning, everybody.
Morning, Judge.
Okay, go ahead.
Hey, can you hear me?
Yes, we can.
Okay, thank you. I'm Charles Greenberg representing Jude Danahee in his efforts to overturn the decision not to award him any visitation with the subject children, Isabella and Marilyn, or his daughters. We take exception now, and of course, my client is in a federal penitentiary in Ohio. He's well aware of what his crime is, but we would also add that dropping the hammer on all visits is something that he takes exception to. I mean, his feeling is that he has tried to maintain a relationship with Isabella and Marilyn. Unfortunately, some of his earlier petitions were delayed because of the pandemic. He's attempted to send them cards and send them gifts, but the courts thwarted, or actually the court, the family court denied him every and all visitation, and we feel that that's a very extreme remedy. This case can be distinguished from Keys versus Halton, where the appellant mother in that case made no attempt for several years for visits, and it was deemed appropriate not to give her any visits. In this case, at least some visits. Now, I mean, if the concern was the underlying nature of his crime, then that could have been addressed by taking a sex offenders program in the federal lockup where he is. I would also add that he's well aware that he's not going to be getting any kind of in-person visits given how far away he is. So with that in mind,
and how much longer does he have on his sentence?
I believe he's going to be released in 2027. That would be his maximum expiration date. I don't know the exact date in that year, but I know it was a 10-year term beginning in 2017. So, but he may get out sooner if he is eligible for parole or any kind of, a merit release at the federal level, but that his maximum is 2027, Your Honor.
Thank you.
Thank you.
Thank you. Are there any other questions? I'll be happy to answer them.
Thank you.
Thank you.
Good morning, Peter DiGiorgio for the respondent. Having been a warrior of family court, I often tell clients that when it comes to children, it's not the court doesn't do necessarily what's fair, they do what's best. And as this court is aware, the standard is abuse of discretion, and is there a sound and substantial basis in the record for the court's determination?
And the court wrote extensively about this, didn't it? A long decision, examined all of the evidence before the court, and then examined the most important thing, which was the best interests of these children. So I would say that that's probably a pretty extensive job that the court did.
I would agree, and the court made two very specific findings right in the decision, that the appellant didn't really have a bond with the children, that 7 or 8 years had gone by where there was no contact, and also, and more significantly, the court pointed out that he kind of downplayed his conviction. He did say that he was just acting as I think it was a corrections officer's duty to undercover to inquire of this.
That no one knew about.
Yeah.
That's right.
And the court balanced all that, and again, although I do have some sympathy for individual parents who don't have any contact with their children, he did let a significant period of time go by that had this application been brought in 2014 or 15 after he was incarcerated, it might have been a different decision. And I asked the court to look at it, cited in my brief. This court did decide the Santoro case, which basically said when the court cited that there was no relationship or bonding with the children and an incarcerated parent, it chose to deny contact. So unless the court has questions, I'll rely on my brief.
Thank you.
Thank you.
Ms. Lorenz?
Please the court, Jennifer Lorenz, attorney for the children. Just briefly, I certainly recognize that denying a parent any contact with a child or children is a drastic remedy. I do think that it was very much warranted in this case, given the facts. So unless the court has any questions, I will rely on my brief.
Thank you. 390, Town of Cambria versus New York Office of Renewable Energy Siting.
Good morning, Your Honors. May it please the court, Carmen Baca on behalf of the Town of Cambria. The Town of Cambria is seeking, through his petition and in his brief, in asking this court to remand the Section 94C proceeding back to ORES to hold an evidentiary hearing on the issue of whether the waiver of the town's local laws was warranted pursuant to the regulations and the evidence.
Well aware.
Thank you. So in support of that argument, I want to stress 3 main points here. One, the initial burden regarding local law waiver is on the applicant to identify the substantive laws that apply to the project. Now, Section 94C preempts procedural laws. However, local laws that are not procedural remain in effect until and unless ORES decides to waive them in whole and in part. In order for the applicant to meet that burden, it must identify the applicable local laws and then offer a statement of justification identifying why that local law should be waived. Included in that statement of justification requires an analysis with facts to describe the degree of burden and why that burden should not be reasonably borne on the applicant, whether the request to waive the local law.
Well, didn't the applicant do that? I mean, they made an application at one point in time, ORS reviewed it, said it's not sufficient evidence, go back, give us more, and I think even a second time they required them to go back and provide additional evidence.
Yes, Your Honor, you're referring to the notice of incomplete application. Nevertheless, at the end of the notice of complete applications, when ORS deemed the application to be complete, it is the town's position that the statement of justification is still insufficient for ORS to find that a local law was appropriately waived, that the request was supported by facts and analysis regarding the degree of burden on the applicant, whether it's the minimum necessary requirement. So, for example, if there is a setback provision, in this case, the town has a setback provision that exceeds the minimum standards of conditions in the regulations. Why is that the minimum necessary requirement?
Was that unduly burdensome then, to have that same setback? Because it would take approximately 200 acres away from this project as far as completing it.
Yes, but to the minimum necessary. So the minimum necessary would, obviously, to the fullest extent, there would be, for the sake of argument, use the 200 acres. However, if you take into account non-participating residential landowners, why is it minimum necessary to not apply the town's law with respect to a residence whose property will now be surrounded by solar panels, to apply the town's law in that circumstance? So it goes back to the point.
Weren't all the landowners in favor of this?
No, Your Honor.
I mean, as far as not the landowners who would be affected by it, the farmers themselves, they were very interested in leasing this property.
Well, one of the landowners was a farmer, a dairy farmer, I believe, and then the second landowner was a individual that owns the land in the town. He is not a farmer, but he rents lands to farmers. And obviously, the people, the landowners that are leasing the lands to the applicant are for the project. However, the land that they lease to the applicant impacts neighbors. A residence that's surrounded by solar panels are now across the street.
Well, isn't the purpose of these particular acts, to encourage non-fossil type energy?
Yes, and
that's the rationale behind this.
Yes, and actually
the reason for a lot of the waivers, because of the fact, because if they didn't have these waivers, it would, in essence, defeat the purpose of these particular legislation.
I understand your point, Honor, and it actually brings me to my second and third points, is that ORES is required to make a finding that the local laws are unduly burdensome in light of the CLCPA's goals and the proposed environmental benefits. Now, I submit that any renewable energy project, whether it be wind or solar, this project or another, inherently contributes to the CLCPA's goals, because one of the goals of the CLCPA is to increase the state's nameplate capacity. Therefore, any solar or wind project will ultimately contribute to the nameplate capacity goals of the CLCPA. However, Section 94C requires ORES to find that it is unduly burdensome in light of the CLCPA goals and the proposed environmental benefits of the facility. And that's where the town believes that it submitted evidence requiring an adjudicatory hearing on the proposed environmental benefits.
The town's evidence was the supervisor and the president of the community, which group that objected to this, correct?
Yes, and through the supervisor offered NISO reports that details that Western New York and upstate New York largely receives its energy from zero emission resources, over 90%. So the question is that quite frankly remains unanswered throughout this entire proceeding, is where is this renewable energy going? The town is not against renewable energy, but to create renewable energy for renewable energy's sake, while waiving local laws that the town has a vested interest in, requires, quite frankly, a hearing without any evidence. Now, in the application materials regarding the carbon emissions that are going to be reduced by this proposed facility are contained in Exhibit 17 and 19 of the application materials. And in those exhibits, the applicant cites two solar industry data studies that speculate and extrapolate that this facility will displace, 200 and.
We have all that in front of us, we understand.
But thank you. And that is not actually. They can't affirmably say that energy is going to displace that carbon resource because, one, we don't know where the energy is going to go. Two, whether the energy is going to actually displace energy from carbon-emitting resources or just simply replace other renewable energy.
Wasn't the state planning on upgrading the transmission capabilities?
Yes, Your Honor. And the state, on behalf of ORES, referenced an Empire State Line in this area that is being constructed, and also two lines in central New York in the Hudson Valley. However, there's no proof that the connection point for this system, this project, is going to be able to access those lines in the future. And ultimately, it's connected to the Mountain Lockport line on National Grid. And all these answers, or all these questions, the crux of the town's argument is that an evidentiary hearing should be held to discuss these issues, because you have to weigh that against the burden of waiving the local law. So if it's ultimately determined through cross-examination and discovery that quite possibly the proposed environmental benefits are over-exaggerated or much less than what are in the application, then waiver of the local law might not be, full waiver of the local law might not be necessary. It might not be the minimum necessary requirement if there is an actually defined proposed environmental benefit.
So that's what you want to have a hearing.
A hearing. And
We understand that.
And if I may end and touch on a point that the amicus party raised in its brief, that the standard for ORA to decide whether or not there's a substantive issue is whether there's sufficient doubts that the applicant's ability to meet the regulatory requirements such that a reasonable person would require further inquiry. I respectfully submit that based on the town's offer of proof in NISO reports and the lack of evidence in the record and the lack of citations to the record of reliable evidence by ORES, that a reasonable person would certainly require further inquiry into the proposed environmental benefits of the facility weighed against the waiver of the town's local laws. That's not to say that the town is going to be successful at that hearing, but there's certainly a need to require a further inquiry into this matter.
Thank you.
Thank you.
Why do you think there shouldn't be a hearing?
Good morning, Your Honors. So I think Cambria fundamentally misunderstands why we hold adjudicatory hearings. We don't hold adjudicatory hearings to explore conjectural theories, speculation, general opposition. We hold adjudicatory hearings when a potential party here, Cambria or anyone, raises a concrete issue, a material fact, a problem with the application, a disagreement with the applicant so serious or as could reasonably contemplate denying the permit. The problem here is that Cambria did not carry its burden. That's why there was no hearing here. So the record, which is extensive, makes clear that the Bear Ridge facility will generate enough clean power to power an estimated 25,000 homes and in the process avoid over 135,000 tons of carbon emissions annually. Those are substantial environmental benefits. So in view of those benefits, ORES used its statutory authority to waive certain local law provisions it found unreasonably burdensome. Cambria argues in its brief to this court that it was entitled to a hearing on two issues, neither of which is setbacks. One is ORES's waiver of decommissioning provisions. As to those, Cambria failed to exhaust those claims by failing to raise them on administrative appeal. The law is clear that this court may not now address those claims. So the question that's left is, did ORES rationally conclude that Cambria failed to carry its burden to raise an adjudicable issue as to the environmental benefits of the facility? So here, and the answer, of course, is yes. So here, Cambria's core argument is that transmission constraints are going to undermine the environmental benefits of the facility. The problem with this argument is that Cambria provides no expert facility-specific proof explaining how these alleged transmission constraints could possibly undermine the facility. And that's notwithstanding that ORES granted Cambria over $50,000 in intervenor funding to hire an expert. So there's no expert proof. What ORES points out, on the other hand, and I should mention, Cambria mentions the NISO reports, Cambria is only relying on outdated analysis from the state's grid operator. So ORES pointed out in this proceeding, newer, more granular analysis from the NISO, the state's grid operator, actually shows that the Bear Ridge facility will be sited in a part of the state with very low levels of transmission constraint. What does that mean? It means the power the facility generates will be injected into the statewide transmission system for use wherever it's needed. The grid is a statewide system, right? Unless it's constrained, it moves electricity from where it's generated to where it's used effortlessly. So the question is there a constraint? The NISO says no. And even if there were constraints that could affect the facility now, ORAS also rationally relies on the state's ongoing planning process for assurance that transmission will be available as necessary in the future. In the same legislation that created ORAS, the Renewables Act, the legislature also charged the Public Service Commission with identifying and procuring transmission system upgrades as necessary to support the state's transition to a greener grid. That process is ongoing, and it's bearing fruit. So the Empire State Line, for example, in Erie and Niagara counties is now operational, and that important new piece of transmission infrastructure was created and built specifically to improve statewide access to renewable power generated in Western New York.
Anything further?
Sorry?
Do you have anything further?
No, happy to rely on my brief for the rest of our arguments. Thank you.
Good morning, Your Honors. Stephen Wilson for the respondent, Bear Ridge. Actually, the AG's office did a fine job in presenting his arguments, which were substantially the same as mine. Unless the court has any questions for me, I'll rely on my papers.
Thank you. 392 North Washington Street LLC versus Erwin Properties LLC.
Good morning, Your Honors. Robert Hooks from the Woods Oviatt office on behalf of the appellant and the plaintiff. May it please the court. Your Honor, we're here today because both sides feel that the court below, in interpreting a written access agreement, made an inherently inconsistent decision. We believe the decision was too restrictive because while it allowed us to continue to use 2 bays that were installed 5 years ago, the court also said, I'm going to enjoin you from installing a 3rd bay door. The defendant feels that decision is too generous, and they are asking this court to enjoin us from using those 2 bay doors.
Counsel, let me stop you there, because the fundamental issue here is, what rights does your client have in Monroe Street?
That's correct,
Does your client have the right, is your client's right to drive across Monroe Street from Washington Street to the back of your property? That's one way of reading it.
Correct.
That's how the defense reads it. You read it, we can use Monroe Street in any commercially reasonable way, including veering off and heading into our building into an overhead door.
That's correct, Your Honor.
Right, so what the court did, though, was, because both sides put in extrinsic evidence, both sides have a different interpretation, the court stopped it and put a restraint on everyone from any additional activity as it relates to increasing or otherwise impeding the use of Monroe Street.
Well,
right? That's how the court said.
That's what the court did, Your Honor. But the role of the court was to interpret this contract, this easement, and we believe they wanted to split the baby. They wanted to kick the can down the road. The question is, this easement, it's not just an access easement. It doesn't just say the easement starts at that side of the room and it goes to this side. Okay? The easement has 3 characteristics that a plain access easement doesn't have. It has the characteristic of commercial use of the property, it has the characteristic of vehicular use, and it has the characteristic of pedestrian use. Now this dais here represents the south side of the building. There are 5 to 6 access doors, multiple entry points into our property that have been there for 60 plus years, that have been there before the easement was conveyed 55 years ago.
Wait, I get all that, but the 3rd door that the court was concerned about was definitely going to take out some parking spaces.
It was going to take
out... So it
out...
was going to change what was happening there that had happened for the last 50 years.
Well, yes, Your Honor, but it wasn't going to eliminate all the parking spaces. And the question, there was nothing in the record below that the defendant said, these parking spaces I'm being prejudiced by the loss of 2 parking spaces. It didn't object for 5 years to 2 bay doors, but it suddenly objects now for a 3rd bay door on the fiction that it's going to affect our parking. But on this appeal, Your Honors, the defendant is not asking this court to rule on our parking rights. It is simply asking the court to enjoin us from installing a 3rd bay door. And it is said the defendant doesn't want to address the parking rights here. We have an incidental right to park, but I don't believe you have to decide that issue today. All that you have to decide is whether or not they establish a probable likelihood of success on the merits and irreparable harm. The defendant has not pled any irreparable harm. In fact, when it was time for the defendant to put in evidence of what they thought was a fair bond, the only thing that they could offer is the expense that they incurred in putting curbs blocking our bays. So at this point, we need not get to the issue of do we have a reasonable parking right? We think we do. But we don't need to address that today. We need to address whether or not the court could have an inherently inconsistent decision where it says you can use 2 bay doors, but not a 3rd bay door.
We'll look at that.
Finally, Your Honor, we would ask that you revisit the fact that they did grant the defendant an injunction, and they waived the requirement that the defendant post a bond. The bond is mandatory, and we ask that the court first reverse or modify the decision enjoining us from installing a 3rd bay door, and if it decides not to, then we are entitled to have an undertaking posted. Thank you.
Thank you.
Good morning, may it please the court. Allison Fute with Harris Beach on behalf of the defendant respondent cross appellant. Just to start, I would like to clarify that in terms of our opposition to the appeal, the defendant here is not asking the court, we are asking the court to simply affirm the order as to the preliminary injunction. We believe that the Supreme Court acted well within its vast discretion in fashioning relief that was fit to provide an equitable interim solution to the parties' dispute here. Of course, if defendants, to us, the status quo would be no use of the doors. However, we understand that the court must defer unless there's an abuse of discretion in the grant of the injunction. And I think, counsel takes issue with our characterization of the imposition of a condition on the granting it injunctive relief. But another way to look at it is that the court simply granted only a portion of the injunction that plaintiff requested, and the provision under review was included merely to eliminate any ambiguity on the ruling. In other words, the court granted plaintiff the relief as to the existing bay entrances, but not the future ones. Would like to just correct that the defendant did not request a preliminary injunction from the court. The reference to asking the court to enjoin plaintiff related to its cross motion seeking dismissal of the first cause of action, which, if granted, would have resulted in an order enjoining plaintiff in perpetuity from using any of the existing bay doors and or installing any further bay entrances. And it's also incorrect that defendant didn't object to the first 2 bay doors. Those objections, plaintiff was on notice of them. In fact, there was ongoing negotiations between the parties to attempt to work this out. The plaintiff proceeded at its own peril in installing those first 2 doors, and if anyone was not diligent, I would argue that it's the plaintiff and not seeking a judicial ruling on these issues prior to commencing the construction activities at the premises. if for some reason the court does not agree that the Supreme Court acted within its discretion and does determine that there needs to be some type of a bond, we would argue that at a minimum, that there should be a nominal bond here because our client did not ask for an injunction and in fact was not granted one. With regard to the cross appeal, the defendant's position is that the easement on its face can be interpreted as a matter of law and that the language utterly refutes the position that's been taken here.
Well, counsel, but you submitted extrinsic evidence. That's what was before the judge. Both parties submitted extensive proof as to how this easement had been used over the last 50 years.
Understood.
And now you say, well, that's a question of law?
Well, the standard for interpreting easements does require you to look at the historical usage. And in some regards, the extrinsic evidence, I guess to the extent it's undisputed that there's no historical use of driving vehicles into the south side of the building as a means of use of this easement. In the example that counsel used, there's pedestrian access points in this building, but I think it would be outside the bounds.
There's a lot of proof that all the parking for the plaintiff was done along the side of the building and people entered along the south side, whether it was in the front of the building or in the back of the building or the side of the building.
Right.
Now they just want to drive in. Instead of parking and walking in, they want to drive in.
And I believe, this hasn't been disputed, that the first cause of action is seeking not the right for incidental parking in common with others, because there are other parties that are using this access road, but to actually have an independent right that's specific to the plaintiff to essentially have to keep that entire area clear in order to allow the vehicles to drive in. So we would submit that Supreme Court could have and should have dismissed the first cause of action.
Thank you.
Thank you.
393 Utica First Insurance Company versus Cody Agency, Inc.
My adversary is
virtual, so we just got to wait for a moment. Okay, there he is. Oh, wait. Mr. Sullivan?
I'm coming in.
Oh, okay, we can't see you, but we can hear you.
Should have the video.
Oh,
I
here,
had
there
blank
you
over
go.
my camera. There we go. Sorry.
Go ahead.
Please, the court. My name is Robert Sullivan. I represent the defendant appellant Baldus Protection Agency. The issue before the court, as framed by the briefs, is very simple. Whether or not the cause of action for negligence accrued on August 3rd of 2018, when it is alleged in the complaint that the plaintiff respondent lost its right or ability to disclaim coverage, or it accrued when it settled the case in January 2021. In the decision in the Supreme Court, Justice Clark relied almost exclusively on a case of Bond versus Progressive. And she distinguished the cases that we cited from Bond, and she was persuaded by Bond. But in looking at the background of Bond, as demonstrated by a related case of Giebel versus Progressive, it's very clear that the decision in Bond made sense, because the claim in Bond was an assigned claim, and it was made pursuant to the direct action statute against the carrier. And under that statute, the claim doesn't accrue until there is an unpaid judgment. So the ultimate outcome in Progressive versus Bond made sense, but that's distinguishable from our fact pattern. We submit that in our fact pattern, in the cases that we cited, significantly Brucker, Venditti, and Northnagel, in Brucker and Venditti, those were cases where an insurance broker failed to get insurance coverage, but that wasn't the date of the accrual of the claim. The date of accrual of the claim was when there was an underlying personal injury action, not yet quantified in terms of a judgment, but an uninsured personal injury action. In those cases, the courts held that's when there was damage incurred by the plaintiff, and therefore.
Counselor,
yes.
Counselor, help me understand though, if your argument is that the damages ripen when there's an inability to disclaim. What are the measures of damages at that juncture?
Well, as we are, the measure of damage is that inability. I know
But that seems kind of it could be potentially like an illusory damage. We don't know whether even the underlying claim has any merit. We don't know what the outcome will be. How would you frame the cause of action and state a demand for damages in that context?
Well, as we argued, Judge, they incurred, and they are claiming in their complaint, attorney's fees incurred in defending that underlying action.
Right, but that wouldn't necessarily be on the day that they could no longer disclaim. That's a future point when they maybe incur their own assigned counsel costs.
Oh, no, Judge, they did that immediately. They did that in September of 2018.
Right. But they say they did that. They say they did that voluntarily. They might have defended the case anyway. They didn't have a duty to indemnify. The duty to indemnify. They lost the duty they couldn't operate under a reservation of rights any longer.
Yeah, but as we also laid out a lot of the background, although it's not germane to the statute of limitations issue, they never tested the ability. They never brought a DJ action. They never did any of that. So to suggest that this is a voluntary payment or not, what they really should have done is undertaken the defense, then brought a DJ action to decide their ability. Part of the problem in this case is at the time of the tender in August of 2018, there was a finding by the Workers' Comp Board that the Feliciano, the underlying injured person, was not an employee. So we have a sort of an odd situation where, based upon Utica First's pleading, they're alleging that they are unable to disclaim. But in fact, it's questionable whether or not that's true. They never tested it. So, what this court must do must guide itself by the allegations of the complaint. And the complaints say that they lost that ability in August of 2018. But one of the cases we did cite, and it's an older case, I apologize, Northrop versus Hill, the distinction is drawn between what are aggravated damages. If they incurred some damage, a negligence cause of action, and here it's the damage incurred by the attorney's fees, at some later point, because it's part of the same wrong, being the conduct being the basis of their inability to disclaim, then that accrual goes back to that original date, as we argued in August 3rd of 2018. So we would submit, Your Honor, that reliance upon bond is incorrect. And I think the more analogous situation are the cases like Venditti. For example, to your point, Justice Del Conte, in Valdante, Brucker and Venditti, where the broker didn't get the coverage, there's an underlying personal injury action. The appellate division said it accrued when that underlying personal injury action occurred, or the injury. But that's the same situation you framed, Judge. What's the damage? It hadn't gone to judgment yet. There hadn't been a judgment against the uninsured individual. It's the same thing. And yet the appellate division in those cases felt accrual was appropriate when there was sort of this not yet defined claim. So we would submit that, and again, because of the background of the bond case, that Justice Clark respectfully placed improper reliance on bond. And I think the better analysis is on Venditti and in the Brucker case.
Thank you. You made that point several times.
I'm sorry, Your Honor?
I said, thank you. We understand that. You've made that point several times.
Okay. All right. I'll move on, Judge. I just want to address some of the issues that were put in response to the respondent's brief. One of the issues, the Scribner's error of asserting the incorrect cause of action, the fifth cause of action, as opposed to the sixth. That wasn't raised in the court below, and I think the case law is pretty clear that it should have been to allow that to be cured. But no one in the court below misunderstood what cause of action was being addressed by the motion in the court below.
And we understand that here too.
Okay. And Judge, what I would do then is I would rely upon our briefs, and if there are any further questions, I'm happy to entertain them.
Thank you.
Thank you.
Good morning, Your Honors. Lester Channon from Farber, Brox and Zane for Plaintiff Utica First, Plaintiff Respondent. The bond case, Bond versus Progressive, is exactly on point as the judge held in the court below. It involved a snowmobile accident.
We don't need to have the exact same underlying circumstances to accept the premise outlined in the case.
It was It was a broker who failed to give timely notice to the insurer. As a result, the insurer never got an attorney for them. A default judgment was taken against the O'Rourke's, who were the vehicle owners.
But you jumped in, Utica, jumped in and defended the claim and came to a settlement, and then the number was apparent.
Yeah, in the bond case, they even had a default judgment against the O'Rourke's because they didn't have an attorney, and that sat for 6 years before they finally got an actual money judgment against them, and that is the time when the court held that there was an actual pecuniary loss that was compensable and therefore was actionable. And in our case, first of all, the attorney, or rather Baldus, failed to even raise the defense cost issue in their appellant's brief, or rather in the.
There's a question.
Yeah.
That's exactly what I was going to ask you about. Counsel says, the damages started when they had to pay counsel fees, okay?
Okay, number one, we disclaimed, or Utica First disclaimed, and then a month later, they wrote a letter and said, we will provide you with a gratuitous defense. A gratuitous defense is not damages. How could we, if it was a voluntary payment, it's classic law that voluntary payments are not compensable, reimbursable, or anything like that. So how could we ever hope to recover it, right? Secondly, we didn't even know, Baldus didn't even tell us that they were late. They're trying to fault Utica First for failing to bring this action in a timely way, but they didn't tell us that they messed up and failed to give us timely notice. So when they notified Utica First on August 3rd, 2018, that there was an accident and there was a claim and so on and so forth, they never mentioned the fact that nearly 5 months had passed before they did that. And it wasn't until, I think it was October of 2020, a month after Utica First got a $1.9 million demand as this case was ripening and ready to go to trial. And all of a sudden, a month later, Baldus confesses and says, here are the notice letters we got, and that show that we sat on this for 5 months. So Utica First had to scramble, right, and try to settle this case as best it could, because I think your honors will know that under 3420D of the insurance law, even a month without, delay is enough to completely knock out a disclaimer based on an employee exclusion, as in this case. So, and so we didn't, the defense costs were not,
You didn't charge them.
Yeah, there was gratuitous defense, but also some of the law states, black letter law on this issue, that you have to be able, in order for statute of limitations to accrue, you have to be able to truthfully allege the elements of a negligence claim. Here, how could we possibly have truthfully alleged the elements of a negligence claim when we didn't know there had been negligence? Okay, and I would point out also that Baldus failed to address the gratuitous payments argument or the truthfully alleged argument, which is in response to their argument that attorney's fees were being paid, and therefore seeded that issue to begin with. They didn't raise it, they didn't address it in their reply, okay? So that in itself, whatever it is, compromises them. As far as the waiver goes, you know, they're claiming there was a Scrivener's error, and apparently there was a Scrivener's error initially, but then they went ahead to the court, they misrepresented the pleadings, and told the lower court that it was affirmative defense, or the sixth cause of action, when in fact their statute of limitations are affirmative defense pertain to the fifth cause of action, which applied to a completely different agency, which they say they have nothing to do with. So then they misrepresented. Right, that in the lower court, they misrepresented that in this court, and now they're asking the court to exercise its discretion in their favor and let it go.
I think we have your argument.
Okay, thank you.
394, Brady versus Sedgwick. Okay, somebody tell me how to say it.
Sedgwick.
Thank you.
Good morning, Your Honors. John Wagurski Law Firm for the plaintiff appellant, John Grady. As the court is aware, this appeal is based upon a decision order from the lower court, which denied the motion to set aside the verdict as being against the weight of the evidence. The trial testimony in this matter and the evidence, I think, is relatively clear and set out thoroughly within the papers. You know, first, if there's any questions from the court, you know, I can address that.
It would be a lot easier of a case if there was a collision that actually took place, wouldn't it?
That is true. I would agree. The fact that there was no contact between the two motor vehicles is not determinative that there was no negligence on the part of the defendant itself.
Except that, you know, the trial resolved that issue, didn't it?
I'm sorry, Your Honor?
You know, the trial resolved that issue.
Resolve the issue of
Of
the
whether there
negligence.
was negligence and who it was on part of, you know.
Correct, and that's the basis for, you know, this appeal itself and the underlying motion to set aside the verdict. It's plaintiff's contention that there was sufficient evidence and specifically testimony, that being of the defendant himself, that he was negligent as a matter of law. You know, as the court can see within the papers and the testimony in the record, the defendant testified that he never saw the plaintiff prior to making his left-hand turn. Not once. He didn't see him anywhere in the roadway, whether it was close to him or, you know, much farther down the road, which was straight. There were no obstructions to his view at all. In fact, he didn't become aware of the plaintiff's presence in the roadway until his passenger alerted him to that fact by saying, "Oh shoot, a motorcycle." And once he saw that there was a motorcycle, the defendant testified that he did become startled. He stepped on the gas to quickly hurry up and try to get out of the way to avoid a collision. However, at that point in time, the plaintiff was already in a skid. He had already began skidding because he actually observed the defendant take a left-hand turn in front of him. Now, at that point in time, it was just a mere matter of a split second that the defendant, luckily, fortunately for the plaintiff, was able to just get out of the road. And at that point, he had already been laid down the motorcycle and then sustained the injuries. It is specifically with that testimony of the defendant that he failed to see the plaintiff at any point in time prior to making his left-hand turn, that the jury should have found him negligent.
Wasn't there expert testimony to the effect that there was more than 200 feet before the defendant made his left turn?
There was testimony to a couple different distances.
And there's two experts, right? Each party had their expert testimony?
There was. There was Mr. Onions for the plaintiff, and there was Mr. Camarada for the defendant.
So isn't that the province of the jury then to determine the expert testimony, who they're going to believe, the credibility of each expert?
Well, the testimony of the expert witnesses goes to the distance based upon, you know, certain skid marks that were in the roadway. And, you know, as the lower court stated in their decision and order, you know, that the plaintiff failed to look at this caveat of a zone of danger. However, the defendant here in this matter should not, you know, be able to benefit from that, because he cannot say whether or not the plaintiff was in a zone of danger when he made his left-hand turn, based upon the sole fact in his own testimony that he never saw him. You know, he couldn't contemplate, well, this individual is so far down the road.
We understand that.
Okay.
He did say he never saw him. We get
Yes.
that. Okay. Anything further?
Any further questions from the court?
Thank you.
Thank you.
Please, the court.
This was a very factual-driven case. It was a credibility-driven case, purely within the jury's province. This zone of danger, we talked about that a lot. Again, there was expert testimony that at the time this left turn was commenced, this motorcycle was not in a zone of danger. And I cite, I don't even know, again, another name I don't know how to pronounce. Catakareddy is the one I cited where it talked
It's a good thing
about
I didn't have to say it.
20 lengths down the road. This, I would submit, is more than 20 lengths down the road. We've got skid marks that if this gentleman was within the zone of danger and going the speed limit, it would have been 63 feet or 80 feet. We've got 118
But again,
feet.
it's
so.
a battle of the experts, and the jury heard.
That's my point, and there was plenty of evidence regardless, I mean, beyond the experts. Matt Strempel said that they were already getting out of the car by the time the motorcycle, came through. The motorcycle, skidded to a stop before before reaching the driveway. And if it stays on its, stays upright, it doesn't even come close to that. It's skidding motorcycle travels further than a braking motorcycle. So credibility, experts, I mean, it all comes down to a very factual-driven result. There's no reason to set it aside. There's plenty of evidence to supporting that verdict.
Thank you.
Thank you.
395, Sampson Lending LLC versus Greenfield Management LLC.
Good morning, Your Honors.
Wait just a minute. Okay, go ahead.
Good morning, Your Honors. Christopher Murray Legal PLLC for the plaintiff appellant, Sampson Lending. The trial court got it wrong, as every appellant says. In this case, the trial court got it wrong for substantively misapplying the law, but also because it reached conclusions that it really could not have reached at a pre-answer motion to dismiss, because those were heavily fact-based determinations that simply are not appropriate at the pre-answer motion to dismiss phase. To overturn the party's choice of law, the party's choice of Virginia law, the court essentially had to...
They had to violate a fundamental public policy of New York.
Yes, Your Honor, but not just violate fundamental public policy. The application of Virginia law under the facts of this case had to be truly obnoxious to New York's fundamental public policy. It can't just be that Virginia law is different from New York law.
We understand that.
And the case law that sort of goes into truly obnoxious seems to really hinge upon states where there's just no usury laws, a Utah. Well, Virginia is not one such state. Virginia has usury laws. They're different, but they effectuate essentially the same public policy, and they represent the choices of the Virginia legislature. Virginia borrowers, protected by Virginia law, choosing Virginia choice of law in a contract. That is what the court decided to overturn here. The other component is that requires factual analysis to go through. The court really had to go ahead and say, not just are they different, but they would be truly obnoxious as applied here. The court would have considered the parties' relative financial positions, their bargaining strength, how Virginia law was ultimately chosen, corporate entities versus individual persons, and was the corporation formed solely to enter into this loan transaction? None of that is developed in the record. What exists in the record on a pre-answer motion to dismiss is that the parties chose Virginia law. There's a factual basis for doing so. That should have been sufficient to survive a pre-answer motion to dismiss. The defendants had a clear and convincing burden here with a heavy presumption against their usury argument. Respectfully, there's nothing in the record that establishes those points. Essentially, at one point in their respondent's brief, they're arguing that plaintiff should have been providing extrinsic evidence on a pre-answer motion to dismiss to overturn their argument. Respectfully, that's A, the opposite of the presumption, and B, really not something that would have been appropriate on a pre-answer motion to dismiss. The next component to this is whether or not New York has a materially greater interest in applying its usury laws in a case where you have Virginia corporate borrowers. Respectfully, Your Honor, none of the parties have cited any authority, because we are unable to really find any, that suggests that New York has a materially greater interest in applying its usury laws to protect Virginia borrowers when Virginia would have considered the transaction to be valid. The policy here is protecting desperately poor people. The borrowers are corporate entities, sophisticated corporate entities, multiple corporate entities. The fact that there's an individual guarantor, New York and Virginia look at this exactly the same way. The guarantor will stand in the corporation's shoes. So the individual is not subject to any different treatment in that scenario either. With all due respect, there is simply nothing in the record that would say that New York has a materially greater interest. Why? Why does New York care how Virginia chooses to protect its residents? It simply doesn't.
Well, one of the issues here is there is no protection for corporations under Virginia law.
Well, there are. Virginia has a usury cap that says that its usury laws don't apply if you're above 5,000 and it's essentially for a corporate purpose. Below that threshold, below that specific exception, they actually have a lower usury cap than we do. They've essentially tried to effectuate a similar sort of public policy end, but they have approached it differently. That's just merely different. That's not material. There's no materially greater interest in applying it there. I would say that this court could, as a matter of law, adopt a bright line, clear test right here today that would resolve this issue. New York does not have a materially greater interest in applying its usury laws to transactions governed by the laws of another state where that state is the borrower's place of residence. I would say that would be entirely reasonable. It would be entirely within the realm of comedy.
I think we understand
Yeah.
your position.
Thank you. Finally, the last component to this would be, a traditional choice of law analysis. If there was no choice of law provision, would, based upon the facts of this case, the court have reached a conclusion that says New York law would have applied based upon that fact-based analysis. That is not an analysis that really lends itself towards a pre-answer motion to dismiss. Generally, it's something that gets resolved at summary judgment. So I would say it was premature based upon the fact that we're a pre-answer motion to dismiss and there's simply no factual record to support it. What exists is simply not there. Unless the court has any further questions, we would rest on our papers.
Thank you. Go ahead, the chair. Oh, very good. Thank you.
Good morning, Your Honors. May I please the court, Albana Petrikov, on behalf of Greenfield Management LLC, Greenfield Senior Living, Greenfield Reflection of Woodstock, and Mr. Matthew Peponis. We respectfully disagree with appellants. The issues in this case are issues of law. The facts are straightforward. This is a contractual breach of contract claim, and the contract presented and incorporated in the complaint as Exhibit 1A, page 32 to 43 of the record, is clear and unambiguous. On a motion to dismiss, it's a deferential standard, so we accept that all the terms and obligations are the way they were presented. If we were to apply New York law, the usury analysis is just based on the face of the contract. There is no question that this is a loan agreement, and the interest rate established under the agreement is 34%. The amount of the loan is under $2.5 million. The initial disbursement by appellant plaintiff was $1,267,500, and respondents defendant obligations to repay had the obligation to repay $1,742,000. So under New York law, application of General Obligation Law 5-521, Subdivision 3 and Section 5-501 allows corporations to interpose criminal usury as a defense. And General Obligations Law 5-511, Subdivision 1 provides that all loans charging an interest rate greater than the permitted in Section 5-501.
Yeah, we understand all that. What about the problem with the Virginia law?
So moving on to the issue whether the trial court correctly refused to apply the choice of law provision, the test is not whether New York has materially greater interest, but whether Virginia law differs significantly from New York law. And in a 2015 decision, the Court of Appeals, Brown and Brown v. Johnson, 25 NY 3D 364. The Court of Appeals engaged in the exact same analysis to determine if the public policy exception rendered unenforceable a choice of Florida law provision without engaging into analysis of the underlying facts. The Court of Appeals acknowledged that to determine whether the public policy exception renders unenforceable the employment agreement at issue, they just had to compare the Florida statutes with.
We understand all that, so how does that apply to this?
So it's similar. In Brown and Brown, there were in both states restrictive covenants, and in both states requirements, and in both states requirement that those restrictive covenants be limited in time, scope, and geographical area, and to be grounded in a legitimate business purpose. However, there were other important nuances in application of the restrictive covenant law that under Florida law were more protective for employers, and under New York law, employers had higher burden of proof effectively. So in this case, Virginia law does not effectively have any meanpful protection for corporations. And
so that's your argument. That's your main argument.
Yes, under New York law, clearly any interest above 25% is usuriously criminal.
Right. Yeah, we understand that. So.
And I would argue that even if you look at material interest, I think New York has material interest to rein in lenders that charge criminally usurious rates. There is no question that Sampson Lending is based in New York, operates in New York. Accordingly, it has significant connections with New York, and New York has significant interest in resolving this issue. Going into the analysis of Court of Appeals decision in Other Base LLC with Genesis Inc. 37 NY 3D 320, the Court of Appeals extensively reviews the history of usury laws and the application of the modern statutes in view of the history. However, there is no requirement to protect only poor people or poor corporations, and there is an implicit conclusion that corporations that need a loan under $2.5 million are poor or cash starved. So in the context of those de minimis amounts, it is a fundamental public policy in New York. The fact that it's a felony to charge above 25% illustrates the importance of this policy against usurious interest rates.
Okay, do you have anything further?
Unless your honors have other questions, I would just emphasize that the statute explicitly requires voiding of the transaction under New York law, and there is no room for reformation, reduction of interest rates. And again, I would refer the court to Other Base and the reasoning of the Court of Appeals as to why there is no other remedy available in the context of criminal usurious loans.
Thank you. 396 Oakshire Properties versus Argus Capital Funding.
Good morning, Your Honors.
You just have to wait till.
Oh.
Sorry. There we go. Can you unmute yourself, please? You need to unmute yourself. Perfect. Thank you.
Good morning.
Good morning.
Good morning, Your Honors. It's Philip Spinella with Murray Legal PLC for the appellants, Argus Capital Funding and Park Avenue Recovery. I'd like to just offer here, hopefully, a distillation of the issues, because there's a fair amount of moving parts in the briefing. I guess I'd like to...
I'm sorry. What am I missing here? I think okay, go ahead.
Okay, thank you, Your Honor. I think I'd like to take the fraud and RICO claims that are remaining first, because I think they can both be disposed of in the first instance for the same and really efficient reason, which is apparent from the face of the amended complaint and from respondents' own statements of facts here. For instance, on page 4 of the respondent's brief, with respondent's citation to the amended complaint, the record cites the amended complaint, quote, Argus advanced $400,005 to the Oakshire entities, end quote. And on page 6 of the respondent's brief, and I quote, Oakshire entities made $234,856.80 in payments. Respondents themselves cite to the judgment of confession that they attach to the amended complaint, and the amended complaint itself explicitly seeks restitution of the $245,851.80 paid to Argus. Okay, so to state the obvious, $400,000 is much greater than roughly $245,000 to take the figure from the respondent's own pleading. You know, the upshot here is that it's evident from the face of the complaint and from respondents' own representations in their briefing here that they have suffered no out-of-pocket loss. And as I think we've briefed extensively in the brief submitted to this court, you know, an actual pecuniary injury and out-of-pocket loss is what is required to plead a viable RICO claim, and similarly, it's what's required to plead a viable fraud claim in New York State. So I'd suggest that because that's on the face of the complaint and it's really indisputable, that is probably the easiest and most efficient way to deal with those fraud and RICO claims. I should speak, I think, at least briefly, to the respondent's contention that they can create a RICO claim by tacking on the legal fees that they're incurring prosecuting this action to try to, I guess, kind of manufacture an amount that is greater than the amount paid by Argus to them. And I think, you know, we cited Bankers Trust in our papers, and I think a really kind of good way to look at how the facts here differ from the facts where courts have held that you can use legal fees for RICO actions, and that is, like, let me get it right, because the facts of that case are fairly complicated, but I'll try to make them simple. That case involves bribery, perjury, fraud, and bankruptcy fraud. Essentially, a fraudulent transfer was made prior to a bankruptcy between two people in a related entity. The entity then filed for bankruptcy, and relying on the representations that the bankrupt entity made in the bankruptcy, the plaintiff in the action, Bankers Trust, approved the plan. Okay, so after the plan was approved, Bankers Trust is owed money, and in an attempt to frustrate that collection of that debt, the entity and the related individuals made more sham transactions and filed frivolous lawsuits. They bribed a judge, all in an effort to frustrate that collection. So,
Counsel, let me say something. Pardon me here. I'm having a little trouble following, because this was a motion to dismiss.
Yes, exactly.
You're digging really deep into this. I mean, when we look at the amended complaint, there's allegations that they're suffering other business losses, other business damages as a result of their contention here is that the initial affidavit that was filed in support of the application for default in Ontario County was misleading and fraudulent. That's their first cause of action. Vacate the judgment of confession.
Yes.
And then they've got a series of other causes of action which are independent of vacating the judgment.
Yes, absolutely, Your Honor. And the 2 points there are related, actually, because simply put, it's actually relatively straightforward. There is no cause of action for vacatur of a judgment. That's the ultimate relief you seek. So in this plenary action to get that judgment vacated, they have to succeed on the merits of one of these underlying actions, and I think there's...
Well, wait, let's stay right there for
Yeah.
one moment, just to be clear, because there's a lot of blending in their brief. But the first cause of action is an attack at the process of your client receiving the judgment by confession. They say that they weren't in default under the agreement, that the affidavit supporting the application for a judgment was false, and it was filed 2 days or a day and a half after they indicated to you they're going to have trouble making the payments under the agreement, and they had every right, because of their revenues failing, to notify you, and you pulled the trigger too early.
Absolutely. So I would say
So how is that not a cause of action?
Okay, so I think actually it could be a cause of action, right? The Ladati affidavit, they allege, falsely represented that there had been a breach of contract when there wasn't, right? As you've said. What they're actually alleging here, that allegation, Your Honor, is based on our alleged refusal to reconcile, as you've noticed. That alleged refusal to reconcile is a breach of contract. It gives rise to a breach of contract claim. There is no breach of contract claim here. It's origin clear. It's cited in our papers, I believe. Such allegations, or refusal to reconcile, may be sufficient to show that defendants breach the terms of the agreement, but the court does not find that such conduct render the provisions illusory. So there may be a viable contract claim or quasi-contract claim on the facts as alleged.
That's separate. That's
I know,
the way I read the amended complaint. The first cause of action is that you shouldn't. There was no default. The affidavit in support of the confession application was fraudulent in and of itself. Then we have the subsequent causes of action, which attack the transaction, the underlying transaction, right?
Yes, absolutely.
Right.
And I would say...
Because your point on the first cause of action is that it can't be filed under CPLR 5015.
That is one prong of that, and the other is that the vacatur of a judgment is simply not a cause of action. That's a relief you seek in a plenary action, and honestly...
Why isn't this a plenary action that they're seeking?
No, it absolutely is. So it can receive that, it can get that relief if it succeeds on the underlying cause of action. This court has a decision from 2021, which I think embodies that proposition. If you look at New Widecap v. Yellowstone, it's at 50 NYS 3D 652. In that case, this described vacatur of a judgment by confession as quote-unquote ultimate relief. This court thus reversed the trial court where the trial court had granted a motion seeking vacatur of a judgment by confession. This court held that, quote, inasmuch as plaintiffs did not prevail on the merits of the plenary action, that was error. I think this embodies the proposition of what I'm saying, that to succeed here, to get the vacatur of the judgment, they have to succeed on the merits of the fraud cause of action, the RICO cause of action, or the substantive unconscionability cause of action. So that's why
I think we have your argument on that, and your time is almost up, so if you want to.
Okay, yes, I would just, again, say that on the face of the complaint, there are no out-of-pocket damages, and it's very, very clear that RICO damages have to be out-of-pocket. It's the same for fraud. The enterprise allegations, it's in our brief. They plead everyone as RICO persons and everyone as RICO defendants. You simply can't do it. I won't belabor re-reciting the law. I would very briefly say, because they've raised the point that there is a proviso in the contract that carves out if Argus fails to do one of the mandatory reconciliations, it's supposed to do every 15 days. It says that's not necessarily a breach of the contract. Now, I would suggest that even though that doesn't preclude, obviously, the counterparty from requesting a reconciliation, yes. However, that doesn't mean the contract's illusory. If they request a reconciliation and it's denied, as they allege, I am not arguing that that might not give rise to a breach of contract claim.
Understand.
Yes. So all I'm saying is that that claim, which may be viable, doesn't exist in this complaint. Thank you. Yeah.
Go ahead.
May it please the court.
Wait.
Oh,
You
sorry,
need to
first time.
Oh, okay. Go ahead.
May it please the court. William Costigan for the respondent, Oakshire Entities, and Gary Schrader. Uh, uh, just a few points that I need to make here. I'll take the last point first. The reconciliation provision, which they describe as mandatory, it's a very important point, obviously, whether or not it is mandatory. Well, it's not. The wording is that if Argus fails to make a account reconciliation at any time, 1 or more months or portions thereof, that shall not be deemed a breach of Argus's obligations hereunder. No reconciliation, still no breach. That's not mandatory. It's the opposite of mandatory. It's discretionary. The appellants have tried to put some glosses on that language to say that only means that if there is not a sua sponte reconciliation. Well, that's not what the contract says. It says if there's no reconciliation, there's still no breach. They say, well, what that really means is that it would not be a material breach. Contract doesn't say that either. It's their contract, and the court should not be hyperextending itself to somehow salvage it. There is no mandatory adjustment. There's no mandatory reconciliation. This is entirely a loan, not an MCA agreement, as Justice Odorizzi correctly found. Moving on to the points with which counsel began regarding our RICO costs and fraud causes of action, I want to emphasize how little of what is currently proffered in this court as grounds for appeal was in the motion below. The defendant's memorandum in support of their motion to dismiss is reproduced in volume 2 of the record, and the relevant pages are 408 to 410. 3 pages in which the defendant appellants argue for dismissal of 5 causes of action. For example, in relation to fraud, there is 1 paragraph comprised of 2 sentences, and it does not raise, much less address in any compelling way, the arguments just made by Mr. Spinelli. At pages 409 to 410, roughly 1 page of text, there is an argument for dismissal of the RICO causes of action, 2 causes of action, 7th and 8th. No argument about out-of-pocket damages, no questioning the adequacy of our damages at all. And I'll just digress for a second to say that at page 127 of the record, paragraph 84 of the amended complaint does refer to other, as the court mentioned, does refer to other damages to Oakshire's business and property. But the motion to dismiss was not about that. Furthermore, the effort to attack our allegations regarding the RICO enterprise, 0 in the moving papers about that. And that's a recurring issue with almost all the causes of action beyond the first. And I would just emphasize that there's 3 pages, 408 to 410 of the record, and almost everything that's been argued on appeal is not in those pages.
Do you have anything further? Thank you. Okay. 397 in the matter of Freedom Foundation versus Jefferson County. Just a minute. going on?
Those should be with yours, Judge. The tech services guys, is the second attorney coming in?
Your Honor, Ms. Fehrenbach is there, but does not look like she has a camera.
Can you hear us, Ms. Fehrenbach? Apparently not. Can we reach her in some manner?
We could try to give her a call.
Okay. Sorry to keep you waiting. Ah, there you are. Thank you. Go ahead. We can't hear you. We can't hear you. Are you muted?
Do the whole calendar until now.
Hmm?
Last case, the first glitch we had. Pretty good.
Judge, we are reaching out to her now.
Yeah, we can see.
Looks like she's reaching out to you.
Judge, we're having her dial in with her phone.
Okay, thank you. Any luck?
Hopefully they can bring an audio only, Judge.
Yeah, but.
Can you hear me now?
Yes. Thank you. Okay, go ahead.
Okay, sorry. Good afternoon or morning. My name is Carrie Fehrenbach, calling for Jefferson County. I'd like to talk about basically the main purpose of FOIL beyond our briefs is for the public to have exposed governmental abuses and evaluate governmental activities. The legislature balanced this by giving exceptions for privacy matters. One of these being what is the center of this case, which is whether or not the addresses and names would be used for solicitation or fundraising purposes. Now, the term solicitation was changed in the law in 2008 to replace the term commercial. The lower court and Freedom Foundation would like to say that solicitation is for the raising of funds only. However, that is what fundraising means. So if the intent of the legislature was for solicitation to only mean the raising of funds, why is it in the statute twice, solicitation or fundraising? It would be redundant. solicitation as a term means to ask for something or to obtain something. It is a broader term than just asking for monetary means. A majority of the cases in our briefs were prior to this change in 2008. A couple of the cases after, Empire Center of New York State Policy versus Retired Teachers New York City, did not deal with the privacy exception because only names were given. And they specifically stated that had a FOIL asked to be able to contact individuals, that the privacy exception needed to be looked at. And then you're looking at NYSET versus Brighter Choice Charter Schools, and they specifically indicated that it looked like NYSET wasn't intending to get these names and information to expose governmental abuses or to look at any governmental activities, but to use the information as a convenient mechanism to get a hold of new membership. And this is the case that we have here. And the county is entitled to rely on this reasonable inference. Looking at Federation of New York State Rifle and Pistol Clubs versus Kelly, we can look at a FOIL request and make a reasonable inference based on the information being requested and the nature and format of it and the requester's organizational purpose to see where this information will be used.
Counselor,
in this instance,
Listen, please.
Sure. I think isn't the website or the goal of the foundation is to take down unions, and organization's website has prominent links to donate and join this organization?
Yes, it does, Your Honor. And while the Freedom Foundation has stated that they're calling to tell our employees their constitutional rights, the question becomes, isn't this just a convenient reason to get names to implore individuals to leave unions? One, what is its governmental purpose? The government is not a union. It's tangential to some employees' memberships or employment. They can be a member voluntarily in a union, but that's not the government's purpose. It does not work as to what the government does. It's not a government abuse.
We understand that.
So our standing is that this has nothing to do with FOIL. It's just a way to gather information and would invade the privacy rights of our employees. And I would take any other questions.
Thank you. Go ahead.
Good morning, Your Honor.
I was so afraid that we weren't going to be able to hear you. Okay, go ahead.
Stella Alcabez on behalf of the Freedom Foundation. This court should affirm the Supreme Court's decision in favor of the Freedom Foundation for 3 reasons. First, the FOIL law requires maximum public access to records, and the burden is on appellants to show that an exemption applies. The county has not met its burden. Second, no cases support the county's broad definition of solicitation. And third, the foundation unequivocally does not solicit funds or membership from any public employees it contacts. So as to my first point—
You deny that your website asked for membership and to donate funds, and the goal is to bring down unions?
Certainly, that the website does say that, but that is not the purpose of the information.
So when you're calling these employees at their work or notifying them by email or their work telephone while they're working, you're asking them, advising them of their constitutional rights, directing them to your website, which asks for them to donate as well. So here's your fundraising. Your solicitation is attempting to persuade them not to be union members.
Well, those are 2 different things, Your Honor. To persuade them not to be union members does in no way benefit the foundation financially, nor does it request membership because we don't have members. Those public employees we're not soliciting funds from those public employees. The information—
If you're asking them to donate, who else are you calling on this FOIL request, other than the public employees?
Oh, the donate button is for other donors that are not employees.
So you're not directing them to your website?
The website that we direct them to is optout.com today, which actually does not have a donate button.
Well, your foundation, you're calling us as part of this foundation, aren't you?
Yes,
You want to call them at their place of work, either contacting them by their phone number or their email address, asking them to, or you're apparently informing them of their constitutional rights not to be a union member, correct?
That's correct.
All right, and then in the meantime, probably also asking them to direct them to their, if you're not asking them to direct them to it, wouldn't it be reasonable for an individual to look at this site, the website now? I got this phone call from the foundation. They want me to, they're union busting. They want me, who are they about? What are they about? Oh, they want me to donate. They want money from me.
Your Honor.
And again, with respect to what FOIL is about, FOIL is to educate the public regarding the government and how it can benefit the electorate. How is this benefiting the electorate by breaking up or advising these individuals they don't have to be a member of a union? How's that helping me as a voter?
Okay, so several
questions, sorry.
Yes. Let's address first whether we are directly soliciting them. We're not. And the 2008 change from commercial purposes to solicitation specifically narrowed the solicitation exemption. So before, if you were indirectly obtaining funds from someone through your website or through getting lists of people, that was considered commercial purposes. After the data tree case, you have to be directly soliciting. We do not directly solicit. We don't ask for money or membership from the individuals that we contact. We only inform them of their First Amendment.
Again, but how does that help me as a voter in this instance? With the purpose of FOIL is to educate the electorate. How's that helping me? I don't belong to this union. How's this going to help me with deciding how I'm going to exercise my right to vote?
Certainly. So that's question number 2, whether this falls under the purpose of the FOIL law. And in that case, informing public employees of their First Amendment rights certainly is of interest to New York in general.
Is the right to speech? Is the freedom of speech right? Freedom of religion? Which one is it?
Yes, the freedom of speech right not to join a union.
Oh.
Since the Janus decision in 2018, it's no longer a requirement that a public employee be a union member. And that is an important First Amendment right that every public employee, of which there are thousands, if not hundreds of thousands in the state of New York, should know about. That further, whether they are union members or do not join a union and do not pay union dues certainly affects the taxpayer. So that's another important this piece of information that public employees should know about.
Okay, we'll look at that.
Generally, all the citizens of New York.
Thank you. Do you have anything further?
Yes, just to continue what I was saying before. So first, the FOIL law and New York case law explicitly state that an agency must produce documents in response to FOIL requests.
Obviously, we know what it says. Okay.
Certainly, but the exemptions are to be narrowly interpreted, and the burden is on the party seeking the exemption to show using actual evidence that the exemption applies.
And again, how's if I'm balancing privacy versus public interest? Why is my privacy interest not to be protected over your apparent public interest?
Because there is no privacy interest in the names and the work.
Yeah, but you're asking for an email address, you're asking for a phone number to contact me at my job site, my workplace, and why am I not entitled to privacy here in my workplace?
There is an explicit case on that point called capital.
Yeah, but that does not allow you for the phone number or email address. That allows you by name, salary, etc., things along those lines. Job title, sure, you can have that, but isn't this overbroad then?
It also permits public office addresses and phone
Sure, the address, but it's you're going to mail me something, you're going to email me.
You're
asking for my email address and my phone number.
Yes, that information is public information and
if you balance it against privacy, though.
But what is the basis of privacy if at its core that information is publicly available under the FOIL law. There is no privacy right to that information. So where is the basis for
So
the
there's no
privacy?
privacy right to my workplace phone number?
There's
Or
no privacy right.
wherein you're going to contact me to, to leave my union?
I don't see a case that says there's a privacy right to that, and without any authority for that, that information is public information. In fact, Capital Newspapers v. Burns explicitly says that names, public office addresses, that information is public. So without any authority, I don't see that there's a privacy exemption that applies. And the burden is on the agency to show that such an exemption applies. They haven't done that.
We understand that. Do you have anything further?
Yes. I just want to say, as to my second point, there's simply no basis in the case law or legislative history to require the county's broad definition of solicitation. All of the cases, the foundation and the county cite in the briefing, hold that solicitation is defined only when an organization is directly appealing to ask for money, directly, not even indirectly. Indirectly would have not been permissible before 2008, but after 2008, it has to be direct. And there's no basis in case law or legislative history to support the county's broad definition. And lastly, as the foundation has repeatedly made clear, it does not engage in solicitation because it does not ask those public employees for money or membership. All of its donations come from elsewhere, from donors, not from public employees it contacts. It simply seeks to inform them of their First Amendment rights. There's no financial benefit, direct financial benefit to the foundation when public employees leave unions. All of their donations come from elsewhere, from other donors, not from the public.
Okay, you've made that point. Anything further?
So given the FOIL law's requirement of maximum access, the lack of authority for the county's definition, and the county's failure to produce evidence of direct solicitation, this court should affirm the Supreme Court's decision.
Thank you very much.
CNA